here. You mentioned that you deal with some narcotics, some offshore gambling as well.
I represented the #2 heroin trafficker in Africa a few years ago.
Walk me through one of those cases that comes to mind that you thought, man, this is just going to be a loser of a case.
They had done a sting and he had sold some heroin to an undercover FBI agent.
And he's turning around, looking at his lawyer in the most
Ready to punch him.
demeaning way.
You know, it takes a lifetime to build a reputation. It takes one bad case to ruin it.
Because just like you, I always like to be extremely upfront. I don't like to sugarcoat anything at all whatsoever.
Was assaulting the younger man, and our client ran in to try and protect him and shot him in the face. And we thought, oh my gosh, how are we going to try this case?
You know, one of the most important legal rights that an accused is afforded to is the right to be presumed innocent.
You know, I like the trial. I like the trial. I like to be in trial. I like to win.
Welcome back, everybody, to Unlocking Success, episode number 3. Today, I have a real treat for you guys. I am sitting across one of the greats, one of the best trial lawyers actually in the state of Texas, potentially the country, guys. I have Mr. Nathan Mays sitting right here, right in front of me. It's truly a pleasure here, Nathan. I thank you for your time.
Oh, thanks, Mario.
I think the audience is truly going to benefit from this. I think it's going to be something where we just want to get to know you a little bit better.
Sure.
Understand exactly some of the challenges that you have faced throughout your lawyer career, potentially some personal challenges as well.
Sure.
What it really takes in terms of, I have this particular challenge. This is the mindset that is required to overcome this challenge and get out and come out on top. That's what we're going to go ahead and discuss here today. Tune in. Nathan, welcome. Tell me a little bit about yourself first, just so that the audience can truly understand who you are.
All right. So I started out as a lawyer. I went to Baylor Law School, graduated in 97, started at the DA's office in Harris County. Spent 5 years there as a prosecutor.
Baylor Law, by the way, sorry to interrupt. Baylor Law is at least from what I understand, excellent law school for advocacy. Can you certify that?
Yeah, they have a focus on trial lawyers, right? Their whole program is kind of designed around, or at least when I was there, it was designed around growing trial lawyers and making people excellent courtroom advocates. And honestly, you know, most law schools, your first year is your hardest year.
True.
Second year is difficult. Third year is usually kind of a coast. At Baylor, the third year is the hardest year you have.
Is that the case?
They have a whole trial court program and an evidence program designed to help lawyers become effective courtroom advocates.
Fantastic. Would you say, if it were for Baylor, you wouldn't be the great trial lawyer that you are today?
I would definitely give them credit for the training that I received. I mean, without a doubt, I think as an advocate, it's the best place that you can go to become a courtroom trial lawyer. Now, there are other great schools in Texas that teach trial advocacy. I mean, South Texas is known for it. Other schools are known for it, but Baylor really puts a premium and a focus on that kind of training and education.
Understood. Okay.
And there have been some spectacular trial lawyers that have come out of Baylor.
Plenty.
Yeah.
You graduate from Baylor Law. You immediately go to the DA's office.
Right. And that was back in the days when it was different than it is now. Right.
Enlighten us a little bit as to why do you believe, or why do you have that take that it's different now?
Well, when I was there, Johnny Holmes was the DA.
The elected DA.
Yeah. He was the head of the office, and he was Johnny was a independently wealthy person. So he didn't have to solicit any kind of campaign contribution or anything like that.
Okay.
He ran the campaign based on, I'm going to do this and I'm going to run the office this way. And he was different than most elected district attorneys, right? Now, we have a new district attorney here. He just got elected. We'll see what he turns out to be. But,
correct.
I started out under Johnny Holmes, it was just a different office back then. There was a premium put on training people to be good trial lawyers.
Good.
During that district attorney's office.
Give me an example. So for that first year that you were at the Harris County District Attorney's Office, from what you can recall, how many trials did you do that first year?
I probably in that year tried at least 18 jury trials.
18? Yeah. And are we referring to county court cases, misdemeanor
Yeah.
offenses?
That was primarily the first year I was there, misdemeanor cases, and then I was promoted to a felony 3.
Okay.
And tried another 15 felonies in the next year. You know, by the time I was there 5 years, I'd tried over 80 first chair jury trials.
80.
Yeah.
Impressive, Nathan.
And then part of that time I was supervising other people because I became a misdemeanor chief prosecutor. And then your job is to train, you know, the number 3s and the number 2s, how to try their cases.
Understood. And pass on some of those golden nuggets that you've picked up throughout your trial.
There was a real training program in place at that point in time in terms of how to become a good trial lawyer, how to try a case, how to weed out what's a good case and a bad case. You know, I mean, once you try a few and you get your ass kicked by some old school defense attorney, you realize very quickly, like, oh.
I've always been in the position, Nathan, where I don't really look at it as a win or lose. My perspective in terms of practicing law, it's always been you either win or you learn. Because it is called the practice of law for a particular reason at the end of the day. You're practicing day in and day out. You're learning something new. At least I always try to aim for what can I learn today that will give me an edge to provide an advantage for our client. Because that's what the duty that we have to fulfill at the end of the day.
Right.
You know, provide the best that we can in terms of our ethical and legal capabilities to advance our client's interests.
Right.
You mentioned that was the distinction between that era to this era today. Do you think they don't have that same focus in terms of making sure that they have this training and the robust of trial experience for these prosecutors? Or what exactly is that big difference?
Yeah, I mean, I think for the past 15 years or so, there's not been as much emphasis put on being a good courtroom advocate. And I think, you know, also you've seen like, over the last 15 years, kind of the rise of diversionary programs at the misdemeanor level.
Mm-hmm.
So you see, you know, when I was a young DA, we didn't have, you know, weed cases for a joint were still being filed. Less than 2 ounces was still being filed. Assault, family violence, there was no BIP class to go take, you know. DWIs, there were no pretrial diversions on DWI, period.
So it's practically the person please or we're going to trial.
Yeah, and so you had this environment where those cases were going to end up being resolved in a courtroom, which gave the young lawyers, both the defense lawyers and the prosecutors, the opportunity to go in there and advocate for their side of things and learn how that feels and kind of get a real taste for courtroom advocacy. And now on the misdemeanor side of things, you know, I don't know what the percentage is of how many cases get resolved with some kind of diversionary action, but it's pretty high, and there aren't that many cases that get tried at the misdemeanor level. So you have young prosecutors coming up without that experience, and then they get to felony court where there still are not a lot of diversionary results.
Opportunities.
Yeah. I mean, they're just not there. And so they get up there and then they're facing, I have to go to trial, and here I am. I've got 3 trials and I'm a felony 3, and I have to try, you know, some kind of drug case. That
aggravated assault case.
That has prison time. Yeah, aggravated assault, or the felony 2s are trying the aggravated robberies. In, you know, they're in a position where they don't have 30 trials that they've already had. And so, you know.
There's a clear distinction.
Yeah.
Clearly, from what you're enlightened.
Yeah, because what you said earlier, you know, you win or you learn. I mean, you learn more from your losses.
Agreed.
People would say. It depends on the loss. I mean, there are some losses that what you learn is I should never have tried that. Right.
As a defense lawyer or on the prosecution side?
As a lawyer.
Understood.
Right. There are some losses where the lesson is, shame on me, I should never have tried that. That's just a part of being a lawyer, is you go, oh, well, that was not the one.
Well, I'm intrigued on that. Are you referring, did you take a W on that case?
Which one?
The one that you're aligning me with right now and saying, wait a second, there's some cases where you try it and you figure, I shouldn't have tried that case. Is it just
sure
because you didn't get a favorable result,
You just didn't see what the real issues were. You know, when you're a young lawyer, understanding everything that goes into trying a case is difficult. You haven't had enough experience. I mean, they can teach you all the rules at law school, and you can learn all of the ways to admit your evidence and object to the other side's evidence and the motions and all of those things. But effective advocacy is more than that, right?
Of course.
You can know everything there is to know about the law and the little nuances of it. Those are appellate lawyers, Mario, right?
Yeah.
They know all of that, but there are more components to being a trial lawyer, right? You have to be persuasive.
Minimum.
Right? And being persuasive is its own art that you learn over time and repetition, and you figure out what works and what doesn't work, and you talk to other people and other lawyers. And then you also have to be perceptive, because with your jury sitting there and figuring out who's the right juror for this case, how am I going to present? What's my message, my persuasive message that I'm going to unload on this jury and ask them to join me and say, follow me, let me take you where I want you to go.
Right.
Right. You have to be perceptive about who the right people are that are on that panel. And that takes time too. Like there's trial and error. Like, is that the right person? Maybe not the right person. Oh, I thought that was going to be the right person. So the perception of who's right for a juror, and then the persuasion, and that's a learning experience.
As you go, you start picking up these golden nuggets.
Yeah.
Totally. You mentioned you were in a position where throughout your experience at the DA's office, you were given this opportunity to really educate and train younger lawyers. What were some of the golden nuggets that you shared off? Aside from persuasion, perceptive, what other true golden nuggets have you shared? Because I'm sure there's plenty, but one that really comes to mind, or a couple that come to mind right off the top.
So, when you're a young lawyer and you're trying your first cases, you try to go watch other lawyers, right?
Yep.
You want to go watch other lawyers. You want to see how they try a case. You take notes. You focus on it. How is he doing this cross-examination? How is he doing this closing argument? How do they argue it? You do all those things, and then the tendency that we all have is we go into court and we try and do it ourselves, right?
Right.
I saw it done this way. I learned this in the CLE.
Let me do that myself.
Right. I learned this in the CLE. I saw this guy do this. It was amazing, and that's kind of the natural tendency, is to mimic or imitate someone we respect and that we admire how they've presented a case. So that's good, and that can help you learn. But what I always try to tell people is, you have to find your own trial voice, right? And so being authentic and being the authentic version of you, not you doing what someone else does, not you saying what someone else does, you being you and presenting your case is the most persuasive thing you can do as a lawyer.
Understood.
And so figuring out how to have your voice as a lawyer, whether it's just negotiating a case to try and settle it, civil, criminal, like having your own voice as a lawyer, and then definitely in trial, having your own trial voice. This is who I am, because jurors really can perceive, especially if you have a trial that's 4, 5, 10 days long.
Yeah.
Like
they'll start picking up on it.
All of the bullshit drops after day 3. Right. They know who you are.
Yeah.
Right. They're watching your body movements. They see all your nonverbal communication between you and your client. And if it's not authentic, if they think they're getting an act, they won't respond to it.
Understood. These are all really good tips. Now, I've seen it, Nathan, where different trial lawyers will take particular measures when they're getting ready to go to trial. And by that, I mean, we have different lawyers who have shared with me as far as I write out my entire opening statement, I write out my entire closing argument, and I want to make sure I study that to the T, to the point where I can try to verbalize word for word what I wrote down. On the other hand, we have lawyers who say, I really just go off the cuff and I just want to know exactly what my client's case involves. What are the circumstances? What are the flaws? What are the strong points? What are the, main points that I want to make sure that I get across? And then I'll just write out bullet points on a particular sheet, make sure that I understand that these are the items that I want to make sure that I flesh out. And I ultimately then go for it. Or somewhere around that mid part, we have individuals who say, I actually record myself giving an opening statement, giving my closing arguments. I'll look at that, I'll analyze it and say, okay, wait a second, I need to change my tonality here when I'm trying to deliver this particular point. And wait a second, I'm not involving certain gestures or certain hand movements. I want to make sure that I also, incorporate some of that so that I can make sure that I keep those jurors focused on me and what I actually want to get across. Are you more of the type to say, I'm going to go off the cuff, or I'm going to type it out specifically and make sure that I convey that to the T?
Definitely not off the cuff.
Not off the cuff?
Not off the cuff. So, I would say for me personally,
okay,
I always have an outline of an opening, right?
Okay.
I have an outline, and I've rehearsed it multiple times, and I've had other people weigh in on what I'm going to say and how I'm going to say it, because, in Harris County, when you try a case, you're trying it to a variety of people. Like, we have a wide variety of socioeconomic backgrounds, ethnic backgrounds, experiences, and I don't ever want to go in front of a jury and just do the first take.
Understood.
Okay. I'm going to play it to some other people and get their feedback so I understand how they respond to it.
Mm.
And that will help me shape a better opening or a better closing or even a better cross-examination than me just going in and saying, I know how to do this exactly, and I'm going to play it the way I want to play it. So, I always have an outline. I don't necessarily type out every single thing I'm going to say. I will have it in my head.
Understood.
But I also feel like when you do an opening statement or a closing argument, there's a part of it that has to be responsive to the jury. You need to be that's where the perception comes in, right? You're perceiving how the jury is listening to you.
Yeah. And
if you open your closing argument with something and a jury, you see jurors who are like, no, I'm not buying that, then you have to make a switch right there.
Mm.
So you have to do some improv, some impromptu adjustment of how you're approaching that jury. Because there's another side. There's the other side, right? The government, the prosecutor, the state, they're giving their side of it.
Yeah.
And jurors are being persuaded by that also.
Of course, because at the end of the day, my closing arguments are really going to be fluid in terms of I have my main points that I want to get across, but it's also a situation where if the case is that I see that certain evidence was presented, certain witnesses were used, or certain arguments were made, I want to be able to then fluidly say, I need to modify my closing argument and make sure that this gets added on so as to try to clear up some misunderstanding, miscommunication, and make sure that the jury understands, hey, wait a second, you heard that from this other side, but make sure you keep this in mind.
Right.
Is that how you do things as well?
Yeah, you have to have some flexibility in what you're going to say, and you have to be responsive to the circumstances as they're developing. And that's true for trial, the overall trial, like the arc of the trial,
right,
as well as your argument at the end or even your opening statement.
Understood. What do you think would be...
Never off the cuff.
Never off the cuff is what you want to make sure that everyone understands. Never do things. And I like that perspective.
That's poor preparation.
I agree. And you know what they say about luck favoring the prepared. You have to make sure that you're ready. Do not ever do things off the cuff, guys. I agree with that perspective, Nathan. Now, tell me, in your experience, what do you think is the most important part of a trial? We recently did a full breakdown where we understood, okay, we realized the majority of the time, people don't even know or understand what exactly are the processes of a trial. And so we engage in making sure that we understand and give a full breakdown to our clients so that they understand and really have this expectation of, okay, so we just wrapped this up. We know what to expect next. And so there's, as you understand, the voir dire here in Texas, which is jury selection. We then get to the opening statements, case in chief, whether it be plaintiff or, the state of Texas on the civil side or criminal side, I'm sorry. We then have, of course, once they wrap that up, you get your own defense case in chief, and then you get your closing arguments. What out of these steps would you say is the most important part, where you actually win a trial? Because there's different perspectives out there. Some say opening statement, some say, and voir dire is where you win a trial. Where would you say, in your perspective, your experience, would be the most important part of a trial?
Preparation.
Understood. Because you want to be ready for anything.
Preparation is where you win. And when I say that, it's because during preparation is when you have to get a grip on all of the evidence, like a Loctite grip. What are these witnesses going to say? What's the evidence going to be? Because during every trial, there will be a moment where someone will slip and say something different. And when you can find that contradiction between what was said previously in the reports, previously in a statement, previously in some kind of, a DEA 6 or an FBI 302, or, you find those contradictions, and you only find those when you're preparing and you have them committed to memory, and what this is what they said previously, and you have notes about it. That's when you can impeach them on cross-examination. But that preparation helps you formulate what is the persuasive argument that I'm going to make that will help me win this case. And voir dire is critical, right? Picking the right jury is critical. Opening statement is critical. Most lawyers would say if you haven't won by the end of opening statement, you can't win. I would tell you it's in the preparation. It's reading all those reports and going through, watching the body cams and going through it all and figuring out so that when they say something on the witness stand and you say, that was a lie, you can then pull it up, go back, impeach them, demonstrate what's happened.
Right.
Because that's what jurors respond to, right? They love the overall story. They love amazing, interesting, fascinating.
Yeah.
But those little moments when you catch somebody, that's when you pull jurors onto your side, right?
Because they start realizing, wait a second, that's inconsistent right there.
That's not fair.
True.
Right. So I always tell people that it's all in the preparation. I mean, the voir dire, critical. But if you're not ready for the evidence portion of it, you can have the best voir dire in the world.
I agree. Now, you had 5 years experience as a prosecutor. What changed? Or what caused you to be enlightened and say, I need to try out the defense side?
I started having kids.
You started having children.
Started having kids, needed to make a little more money. So left the DA's office and went into private practice.
How long have you been a private lawyer, I would say?
22 years.
22 years that you've been given this opportunity to be both on the defense side and on civil cases as well.
Right.
What have you noticed as far as distinction goes, aside from just being, well, we're trying to defend someone's privileged rights under the Constitution, to I need to prosecute, I need to seek justice? What exactly would you say is a major difference that you notice aside from these things that I've just highlighted? From being a prosecutor to a defense lawyer.
Oh. I mean, when you're a prosecutor, you kind of have everything given to you, right? You can get the police to do things for you, investigators to do things for you. As a defense attorney, you kind of have to do it yourself or hire an investigator to work for you. And so you have a lot more responsibility to go figure out the alternative explanation for what happened. So you don't have the resources.
Clearly different.
That you would have. Yeah.
Got it.
You don't have the resources. And yeah, I mean, it's a different, those are two different areas completely.
Got it. That you, in your opinion, would be the grand distinction technically from prosecution to defense side. What do you enjoy the most?
Oh, I enjoy being a defense attorney.
Defense attorney.
It's much more of a challenge.
So you like someone having this underdog role?
Yeah, it's much more of a challenge. And, you know, most of my practice is in federal court now.
Got it.
And in federal court, you know, the government has the FBI and the DEA and ATF and Homeland Security, and they have all the resources in the world to put their case together.
Right.
And so you are truly the underdog in federal court. And so it's much more of a challenge to get a good result in those cases.
Now, there's, last I read on it, there was a percentage that really was mind-boggling to me in terms of federal cases where individuals who have been charged with a federal crime, and the data may have already changed, but there was a percentage in terms of 95% of cases that get charged at the federal level result in some type of plea. 5% who say, I'm not going to take a plea, who go to trial. 3% end up with a guilty verdict, and 2% end up with a not guilty verdict. Now, that may have changed. This was back when I was in law school. Is that somewhat fair to say in terms of that, those numbers, that data?
Yes.
Why do you think that's the case? Is it because of the unlimited resources that the government has?
Well, they're much more selective. Right.
In who they're going to charge or how they're going to be charged?
Yes.
Got it.
Federal prosecutors, so it's very different than state court. State court prosecutors kind of get what they're handed.
Okay.
From the police.
Right.
On the federal side, the federal prosecutors get to kind of direct.
And build up their case.
They direct the investigation. They meet with the agents and say, you need to get me this. We're going to do this kind of grand jury subpoena. We're going to, you know, the agents come to them and say, can we get a wiretap under Title III? You know, can we get this subpoenaed? Can we get these bank records? Can we do all these things? They build that case in the background while the person has no idea it's being built, right? So when they bring a charge against somebody, they have a much more sophisticated structure to their case because they have orchestrated it from the beginning.
Since day one.
Yeah.
Compared to at the state level, as you stated, they're really just given.
Yeah. It just
what
shows up.
Got it. Understood. Now,
they have a high conviction rate because they're choosing how it all goes down.
And how it gets built out.
And if they don't get what they want,
Understood.
They don't charge it. Right? If they pull the records and it's not there,
this is not the one.
The feds will say, no. Put the Title III wire intercept up on somebody, you don't catch any calls, no.
Disregard. Understood. Understood. Now, tell me or enlighten me a little bit about what exactly are the type of cases that you handle? Well, that you handle both at the state level and on the federal level. And now you deal with personal injury matters as well.
Yes.
So give me the understanding as to what kind of cases you do at the state, federal, and personal injury.
So, you know, my state practice is kind of limited to former clients that I've represented in the past. I don't try to go find state court cases. They're usually clients who I've represented on something else, or it's their kid. And so that's a wide variety of things. Federal court, I've represented historically a lot of people involved with narcotics trafficking.
Got it.
A lot of people involved with healthcare fraud. mortgage fraud, SBA loan fraud, those kinds of things. And I've also represented people in the offshore sports gambling industry
as well,
charged in RICO conspiracies and money laundering conspiracies and that kind of thing. So
interesting, very interesting.
Those are a whole different animal.
I bet. It sounds like there's quite a bit of paper that you have to go through as well.
A lot.
Do you have
a lot?
I know you mentioned right now, you pointed out how on the defense side, it's really up to you and how much resources you can allocate to be able to, adequately prepare for trial. Do you engage in having investigators, having people that can assist you in making sure that they're going through this evidence with you as well?
I do. So, historically, I've always had some young lawyers working with me in going through all the documents that are propounded by the government on federal cases. Investigators, I think, are good for go find witnesses, go track down these documents, take an interview from somebody, that kind of thing. There's some former FBI agents that I've used as investigators to help me analyze bank records and that kind of thing.
Got it.
The federal side, you get a lot more expert witnesses too, where you might have a forensic accountant working for you. Okay. But at the end of the day, you need someone to have eyes on it who understands what it is they're seeing. Right.
Got it. Now, a lot of people don't know this, but there is under a case that, I can't remember the exact name on it, but it's Ake motion, they call it, where at the state level, you can petition a court so as to consider granting the opportunity to obtain state funds that can then be utilized to retain an expert on the defense side. And the experts can vary. It could be, as you stated, a forensic accountant. It could be a private investigator. It could be a forensic psychologist. It varies depending on the situation, right?
Right.
Is that something that is accessible at the federal level?
If you're appointed.
Only if you're appointed.
Right.
So if that person has a retained lawyer, it's out the window.
You end up in a series of hearings in front of a magistrate where they're questioning the person about what their finances look like, what resources they have that they could contribute towards hiring experts to do certain things in the case. In state court, even if you're retained, depending on the case, like on a capital murder, you can probably go get a series of people like a mitigation expert, forensic people. Yeah. You can get DNA experts. You can get what's it called? Like a cultural kind of consultant to deal with if the person is not, native born U.S. citizen, all those things. In federal court, it's a little more cut and dried. If you're retained on a case where there's significant allegations, they're going to say, well, we got to go into this guy's finances and figure out what he has.
Before there's a decision. But you're saying it's potentially still accessible.
It is potentially still accessible, but it's also a situation where in federal court, if you want an appointed lawyer, they're going to give you one. Right? Regardless of your finances almost.
Is that the case?
Yeah. In my experience, I've seen people where they go, okay, well, you have a little bit of money, you can pay, we're gonna give you a lawyer, and then you can pay back at X number of dollars a month towards their fees.
Understood.
They're far more protective of the eventual conviction by saying, "Oh, we'll give you a lawyer if you need a lawyer."
Got it. Because they're trying to protect.
They are all about the record.
Understood.
Conviction integrity, they would say.
Okay, that's a proper term.
Right.
This is at the federal level.
Yeah.
You've enlightened us with the state level cases. What about the PI side? Personal injury. Mm-hmm. What kind of cases are you handling now?
Well, so I'm pretty new at the PI side. I've always had clients call me about personal injury claims and that kind of thing, and I've referred them to, different lawyers over the years. And one of my best friends opened up a personal injury firm 10 years ago. And
here in Houston.
Yeah. And Clive Markland. And he always, said, hey, come practice with me. He's like, you're a great trial lawyer. Come try these cases. And he finally convinced me. I finally conceded that I should give that a try. So I'm doing that now. They tend to be catastrophic injuries, wrongful death type cases. He and I tried a case about a year ago in San Antonio and got a $82 million verdict
My
on a
God.
wrongful death.
Congratulations to the family.
Yeah.
Now,
Well, I mean, they would much rather have their daughter back.
of course, of course.
Right.
That's the serious part about personal injury cases. You're really dealing with some folks who, you can't really compensate them
Yeah.
at the end of the day.
It sounds like a lottery win, but they would very much rather have their daughter than any amount of money.
Agreed.
Like there's no dollar figure you can put on losing one of your children.
I agree wholeheartedly. Now, what would you say, Nathan, is what is required for a trial lawyer to have in terms of certain habits that they engage in, whether it be a daily habit or a particular mindset that is required to make sure that you stay at the top of your game?
I mean, discipline.
Discipline.
You gotta have a disciplined life, right? Just it's part of excellence in any field, right? Being disciplined is part of excellence in any field. And when I say that, it's the reading what comes in, reading the documents, reading the reports, going over them, understanding them, just being disciplined about looking at every case, understanding everything that's going on, getting things filed. That's to me, that's the first step. That's part of that preparation phase, right? Okay. And then when you get to the trial part, there's a piece of creativity that comes in, and that's where you're finding your own voice as a trial lawyer.
This is where you mentioned you have to make sure that you're consistent on the discipline to be prepared, to understand what you're going to face, and to be able to dissect it. But is there any particular routine that you normally engage in? Because you start hearing about how, in order for you to be successful, you got to wake up at 5 a.m. and you got to do a plunge and you got to go out there and run 5-10 miles. I mean, what exactly is your daily routine? Walk me through it.
Oh, that varies wildly day to day, right? It just depends on what day it is. But, if I'm getting ready for trial, then, I'm kind of blocking everything out. Like I'm intentionally closing down my docket for the period I think I'm going to be in trial, right? So if I think, I have this 3-week trial coming up, then I'm going to kind of shut out the noise. I'm going to have somebody else taking my calls on new cases.
Got it.
I'm going to pull the file. I'm going to get alone, right?
You said alone?
Alone, where I can really kind of go through the file again myself, make sure it's all the way I want it to be, make sure there aren't any missing motions, there's not any deadlines, there's like all of that.
Everything's to the T.
That's just part of being prepared. And then, we'll do focus groups on cases that we're going to try where we'll present it to a focus group and see what their response is. We'll do mock trials. Those are all pieces of really getting feedback from people outside of the law world, right?
Got it.
Because in your own world, you can kind of create an echo chamber.
Yeah.
Right?
That's an issue.
Of people who are just, yeah, that's the right thing. Do that.
A yes person, huh?
Yeah, and you got to get outside of that. So
to have a different perspective. And that's something that we were chatting about here before we began this podcast. You just got back from India, is the understanding?
Yeah.
And, one of the things that I asked you specifically, I see that you're traveling out to some, foreign locations where the majority of people may not actually make that intentional decision to say, I'm going to go specifically to this location. And some of the feedback that you provided was because I want to gain perspective.
Sure.
I want to understand how somebody else may live, their day to day, what their life attitudes may be. And you do this with the intention to then come back and be able to have and acquire some empathy.
Yeah. So, people have said, every single person you ever meet in this world knows something that you don't know, right? Somewhere inside of them, they have learned something that you don't know. And if you talk to them and get to know them, you can find out what it is. And then you know more than what you started with. And so I always travel, I love to travel to, great locations, impress, like high-end stuff.
Top of the line.
Yeah. But I also like to go see, how do people in other countries and in other cultures with a different perspective on life, how do they live? What's their experience day to day? What are their struggles? What are they going through? How did they come to this point? And, it gives you a real appreciation when you do that, because you realize, like, I was just in India and I saw, the extreme poverty in old Delhi. And you think to yourself, well, I could have been born here, right? I wasn't, but I didn't choose that. That just happened to me. I happened to be born in the United States. They happened to be born here. And this is what their life is and the struggle they have. And it gives you empathy for them. And it gives you kind of a perspective about our world, that there's a lot of chance that's involved in the outcome of our lives, right? And it starts from the day you're born.
Agreed.
Right? And when you see that and you kind of process it, it helps you when you come back to say, all right,
lucky to be here.
I'm so fortunate that this is my life. And most of it wasn't my decision. The biggest piece of it, where I was born, when I was born, what gender I was born, what background I was born into. I didn't choose any of those things. It just happened to me.
Right.
Right. And so when you kind of embrace that as a person, it helps you communicate with other people. And it helps you be persuasive to other people because you see the struggles that they're going through. It makes you a better trial lawyer.
Agreed. Now, Nathan, you mentioned at the federal level, taking it back here, you mentioned that you deal with some narcotics, some offshore gambling as well.
Yeah.
What would you say? Because we all have, 1, 2, 3 cases that can immediately come to mind as far as, oh man, this case was one of those cases that, my God, may have been the most difficult case, whether it be client-wise, allegation-wise. What has been one of those cases that comes to mind? And I'm sure you have many, but what is one of those cases that come to mind that you think, man, this is just... Because I'm sure you have plenty of war stories. Walk me through one of those cases that comes to mind that you thought, man, this is just going to be a loser of a case. And you somehow found a way to find a viable solution for that particular case. Anything that comes to mind.
So 2 cases, 2 cases that come to mind.
Okay.
So very early in my criminal defense career, I tried a murder case. I was fortunate. I worked with a lawyer named Chris Flood here in town, and he and I tried a murder case together where a lawyer shot his gay lover in the face from about 2 feet away, right? And I can't put names on it because it's all been expunged.
Of course. I agree. Okay. No,
right?
No problem.
So we tried that case, and it was really...
Because right off the bat, I'll let you know, the allegation sounds...
It's 2004.
Rough.
It's 2004, so it's not now. 2004, and it's 2 gay men, and they had a younger gay man living with them, and it was a
roommate situation.
Yeah, it was a 3-person drama.
Okay.
And the victim who got shot was assaulting the younger man, and our client ran in to try and protect him and shot him in the face. And we thought, oh my gosh, how are we going to try this case? It's defense of a third person, but it's Houston, Texas in 2004.
Way different.
Because
I would consider Harris County right now being one of the liberal counties in the state
Sure.
of Texas.
Sure. But
Back then, you're saying it was not.
no. And you know, we went through the process of how are we going to try this case? We're going to have jurors who just think the whole thing is bad no matter what because it involves gay men. And that was a very challenging case. And, you know, we tried it. And from the beginning, we had the perspective of we're just going to put it all out there from voir dire and opening statement all the way through the case. And we're just going to say it until the jury doesn't care. And
The fact that there was gay individuals involved.
yeah,
Got it.
and that it was two 35-year-old men and a 20-year-old, right?
Got
So there was that kind of aspect to it. And we tried it and we got a not guilty on it. And it was,
Congratulations.
that was when I realized, you know, oh, preparation, persuasion, and perception of what the jury is really thinking and understanding about the case. So that jumps out like that was
Immediately. How long of a trial was that?
it's about a week and a half.
Got it.
Yeah.
Did you second chair that or were you fair share?
I was second chair.
Second chair.
Yeah.
Now, there's understandings here whenever you have a second chair, you either can break down, hey, I'm going to do opening, you're going to do closing, or you're going to, voir dire, you're going to handle this particular witness. Was that an understanding that you guys had before going into this trial? Or was it, hey, the first chair is going to be doing the first chair? What exactly was that breakdown? Or is it something that you regularly have an understanding moving forward here now as you handle your trials as to who's going to do what in terms of first chair and second chair?
That was, we broke it all down ahead of time. Who was going to do the voir dire, who's going to do the opening statement,
Understood.
who's going to take which witness. And we had our strategy kind of set. Like, we're just going to put this all out there as cleanly as we can, and we're going to repeat it over and over and over again until the jury no longer is affected by it.
Got it.
And that was a great lesson for me, right? Because it taught me the value of having a persuasive theme, and also the value of you can inoculate a jury to the fact in the case that might be prejudicial, right? So we thought, all this the gay side of it might be prejudicial.
Right.
And there might be some jurors who respond to that in a prejudicial way. But by putting it out front and over in voir dire and opening statement with all the witnesses, it became a situation where the jurors just,
They weren't affected by it.
they just put it to the side and moved on with the analysis of the facts and the evidence and the
Good.
testimony.
Good.
So, and I used that later in my career.
In your other upcoming trials. Great
Yeah.
strategy right there. That's one trial you were telling me about. You mentioned there was two.
Right. So I also tried, I tried a case in Oklahoma City that was a racketeering conspiracy, a RICO conspiracy.
Serious.
Right. 54 defendants in federal court
God.
charged with RICO conspiracy, money laundering conspiracy, many counts of money laundering, and operating an illegal gambling business.
Okay.
And so I tried that, and there were 4 trials.
I was about to say, how does that work in terms of the trial? Because you mentioned 54 defendants, co-defendants, I'm sorry. How exactly do you have an understanding well ahead of time as far as, okay, my client's case is going to be one of the first trials that's going to be going? Or is it just, hey, we're set for trial and we just got to be ready?
Well, in federal court, the judges are much more kind of forthcoming about what's about to happen.
Okay, good.
You're not on a docket with a whole bunch of other people waiting to see if you're the guy.
Right, exactly.
Right. And so I had the number one defendant in the court split. There were 22 defendants that went to trial, and then a whole bunch of people pled guilty. And the judge split the trials and said, we're going to have 4 jury trials.
Yeah.
We're going to try these 5 people. Then we're going to try the number one guy by himself,
So yours was simply your client.
solo. Then we're going to try 2 more trials with 7 defendants each.
I guess that's an advantage, and correct me if I'm wrong, because if you're able to see how that first trial plays out and what arguments are made specifically, it gives you an edge for your trial. Isn't that the case?
You would hope, right?
That's not the case.
They all got convicted. Right?
Got it.
So they all got convicted in the first trial, and then we had the second trial. And I represented the person who was in charge of the entire offshore gambling operation.
Got it.
And we were fortunate, and we were able to get an acquittal.
You got an acquittal
On the RICO conspiracy, right?
My God. Even though these other co-defendants got convicted.
Yes. So we got an acquittal on the RICO conspiracy. We got convicted on the gambling. We got the 12 money laundering counts dismissed. But everybody else in the case got convicted on the RICO conspiracy. The first 5 guys, the 7 witnesses who testified against my client and said I pled guilty to the RICO conspiracy and he's my boss because I did illegal gambling and money laundering. And then in the other 2 trials, everybody got convicted.
What do you think was the distinguishing factor for your case?
The preparation.
The preparation and the discipline.
So we caught one of the lead agents lying under oath in the middle of the trial. And he was a former deputy director for public integrity at the FBI. And we were able to catch him and make him admit on the stand that he had lied under oath.
My God.
About a fact the government was contesting in the middle of trial. So when
Jurors didn't like that.
Yeah, when that happened, it's all of the preparation, right? So we had a theme, how we were going to approach the case, how we were going to be persuasive about it. You know, I said 300 times in trial, it's the legal, licensed, legitimate sports betting company in Panama that pays taxes in the U.S. and pays taxes in Panama. And we said that over and over and over again. But it's also the perception, right? Because when we're picking the jury and we're looking at who are our potential jurors, we looked at their backgrounds, and I see a guy who's a stockbroker for Edward Jones.
Okay.
And I think, that's a good juror.
Because he's going to know numbers.
Well, that guy might bet on sports. There's a chance, right? And we had a lady, and we looked at her, and I go, her husband's a golf pro.
Mm-hmm.
He might bet on sports. He might be a bookie.
For all we know.
He's a golf pro, right? And so that's the perception side of it, is like reading what's behind the scenes here that could help us.
So you're really, in essence, you're really looking for someone who may be similar, who can understand your client's position as a potential juror. Because the way that I go into my voir dire is I want to understand that person's life experiences, attitudes, and any biases that they may have, so that I can then figure out, is this going to work towards what our client's position may be? Or is this going to work against our client's position? What is that part of your strategy here for voir dire? Or are you just looking for, is this person going to understand some of the actions that occurred here based off of the circumstances?
Yeah, so I always think of it as, who's going to have an open mind, right? Of these potential jurors, who will have an open mind to hear us. So many times jurors come in and they're closed. They already have pre-decided before they got to the courthouse.
Right.
Right. Who's going to have an open mind and be able to hear us? And then who could empathize, right? Who could empathize? You know, in the case of the first case I talked about, you know, which juror is going to be able to listen to this and set aside this factor that society at that time had an issue with, and be empathetic and say, oh, this guy was just trying to save somebody, right?
God.
This guy's just trying to save somebody's life, and thought he really had to do it.
Understood.
Right?
So you want to find the individuals who have an open mind.
Yeah.
Understood.
And are empathetic.
Empathetic towards your client. Got it. Understood. Now, from these cases, Nathan, I mean, do you, in handling federal cases, because you hear it from different federal lawyers as well. I've handled so many cases that deal with narcotics, and if there's a particular country, I try to stay away from that country. I can't travel out there with my family. Is that some of the setbacks or some of the negatives in being a federal lawyer?
I don't think so.
You haven't, in your career, you haven't experienced a situation where you think, man, I just can't go there because I currently am handling this type of case or representing so and so.
I think as a general rule, as long as you are upfront with the client and very clear and you manage their expectations, right? And you tell them very clearly, this is what you're facing. These are the possible outcomes. These are the issues. This is the evidence against you. As long as you're very clear and honest with them,
upfront.
I think lawyers who have that fear, they get into that problem because they give somebody an unrealistic expectation.
And they overpromised.
Right. And when it goes bad, they think.
Right.
And the client's like, hey, you told me this. So, it's always a better practice to underpromise and overdeliver.
Oh, man. I agree.
It's just to overdeliver. Because you know what? Nobody will ever come back to you and say, on a federal case, you told me I was going to get 8 years and I only got 3. Why'd you lie to me? They won't say that. They'll say, oh my God, thank you so much. I can't believe I only got 3 years. Let me give you a hug,
Because I've seen some videos, Nathan, as well, just recently here, where I think the gentleman who was standing right next to his lawyer as he was getting sentenced, he hears this gentleman, the judge issuing out 20 years, because there was multiple different counts, 20 years for this count, consecutive years, of course. There's 5 years for this count. And he's turning around, looking at his lawyer in the most
ready to punch him,
demeaning way. And I'm thinking, what did that lawyer say? Because just like you, I always like to be extremely upfront. I don't like to sugarcoat anything at all whatsoever. Why? Because we're dealing with someone's life at the end of the day.
Absolutely, Mario.
And they're going to be dealing with some serious consequences that not only themselves are going to have to deal with, but their family members, the people who are around them, they're going to have to really deal with those repercussions.
Absolutely.
And so any client that comes our way, we always want to be completely upfront, straightforward, and we let them know, look, we're not going to sugarcoat anything at all whatsoever to you. This is how it's going to be, and this is how things work, and this is how we're going to dissect, and every step of the way, you're going to be informed. So you know exactly what is going on. Are you of that type as well?
Absolutely.
You have to be.
You have to be. I mean, there's no other way to do it. Right. We get one, it takes a lifetime to build a reputation. It takes one bad case to ruin it.
Agreed.
Right. It takes a lifetime to build a reputation. And as soon as the client says, oh, you lied to me, you told me this, you've crushed it.
Has there been any type of case, Nathan, that you think, because of this case, it allowed me to then open up a completely different area of, not necessarily specialization, rather a different area where now clients are thinking you're the go-to lawyer for this particular type of allegation?
Well, I mean, I think with the gambling case that I was there, and then, so that resulted in my client got convicted of the illegal gambling and got probation.
Beautiful.
And all the people who got convicted of the RICO conspiracy also got probation because the judge said, I can't give probation to the number one and put you guys in jail. Right? So 21 people all get probation on the same day in federal court, which is probably a record. I haven't looked it up, but I can't imagine that's happened before.
Right.
And I thought, oh, great, man, I'm going to get every gambling case, all the offshore sports betting, illegal gambling stuff, that's all coming to me. And then the Supreme Court struck down the
statute,
Professional Amateur Sports, Protection Act, and made sports betting legal in the U.S.
Yeah.
And I was like,
oh man, there goes that.
It literally happened the day after the sentencing.
Seriously.
I was like, that you just crushed me. That was my, that was my window.
there's quite a bit of different changes here, especially now that we have a new administration in terms at the executive level of our country. And recently here, there's been some new executive orders issued in terms of, well, we're going to classify certain, Mexican cartel organizations as terrorists. And matter of fact, this week, if I'm not mistaken, there was a new article that came out that 28 individuals were brought over from Mexico who were in custody, by the way, but they were brought over to the United States to face prosecution in the United States. One, let's break that down. Is there a big difference in terms of these organizations being classified as terrorist organizations compared to not having that classification?
There is.
What exactly is that difference?
So when you put that kind of classification on to an organization, and I'm using that term loosely, the way the government does, it gives them additional investigative tools. And, you get under the Patriot Act and some of those things that will give them access to do things that they couldn't do in a normal investigation. The Patriot Act, I'm like throwing everybody back to 2005, but, so they're doing that because it does alter, A, the techniques they can use for an investigation, and B, it can also influence the punishments, right? So when I was a young lawyer, there was what we always refer to as the kingpin statute, where the government could designate someone in a narcotics trafficking multinational organization as a kingpin. And it changes, like, can you get paid as a lawyer? Do I have to get approval from the DEA to get paid?
To even sign on to the case, you would have to get approval if they had that classification of it, the kingpin.
Yeah, they become, there was a whole list of organizations where you couldn't take any money from them to represent them without approval from the government.
And if you recall, what exactly were those factors that the court would consider to determine, okay, I'm going to allow you to get paid?
Well, it's not the court, it's the government.
The government?
Yeah, you have to ask the government, can I accept this money to represent this person in court?
How is that fair, Nathan? Because...
Well, it's not fair.
Well, at the end of the day, right, we understand that. But, because at the state level, as a matter of fact, at the federal level, in my professional opinion, one of the most important legal rights that an accused is afforded to is the right to be presumed innocent. How is it fair for the government, who is given this responsibility and obligation to have a burden to prove an allegation, to also dictate and say, well, wait a second, this person can actually retain this particular lawyer. Oh, no, wait a second, this person cannot get this lawyer.
So I think they referred to him as a special designated national. But the list is still out there, right, of these individuals. And it's still, there are still people on it, and there's still people being added to it. And so when you change cartels to be terrorist organizations, they can move them into that category and kind of control their representation. And it opens up international treaty things to, as far as seizing funds, as far as surveillance in international places. So that's very complex. We don't have time to go into all that right now. And I'm not prepared to talk about it right now.
Got it. That makes sense.
But, okay. That move is done with an eye towards making it more challenging for them to have representation.
Understood. Now, with that second prong here of the question, which is, now that they've, had this agreement between the Mexican country, Mexico, and the United States to bring these 28 individuals into the country, is that a power move that's being done here by the executive, or is this a particular reason why we're bringing in these individuals? I don't really understand exactly why that's happening.
Well, one at a time, it would seem like they've run through their appellate review process in Mexico, and they're going to be extradited. But when you grab 28, 29 at the same time,
right,
and pull them in, what it says is there was a concession of some kind made in the diplomatic level. We're going to give you these 28 people you want.
Don't hit us with terrorists.
In exchange for what? We don't know. But they didn't all finish their paperwork and their amparos on the same day, right?
You would figure.
Yeah, no, they didn't, for sure, right? Like they all got pulled at the same time, and there's some big names.
There is.
There's some kind of highline people, and that's not diplomacy or State Department work, Mexican State Department all working together to say, oh,
got it.
That's
wouldn't there be some type of constitutional violations in that
if you can find it?
If you can find it.
I mean, how are you going to find that?
And that's, I guess, not violations of the Constitution of the United States, rather their native country.
Yeah.
Got it. Yeah. That's very intriguing, to say the least.
That's a mystery no one will solve, right? But I mean,
well,
Mexico,
I'll tell you this because,
for whatever reason, Mexico decided, here, take them.
Got it. Because I'll tell you this. So I was born and raised in a border town that's called Eagle Pass, Texas.
Sure.
And you actually saw personally, how these organizations were just running havoc out there, And now that we see these actions being made, I'm thinking, well, what exactly is the true motive here for that to be taking place? Any idea, any feedback on that?
For the mass extradition?
Correct.
I mean, that's a press release, right?
That's all of it.
That's a press release.
Got it.
That's a joint press release.
Now, do you think of course it varies case by case, but do you think they actually have some type of opportunity for an adequate defense here in the country?
Case by case.
Got it. It's going to vary.
Yeah. Case
Understood.
by case.
Understood. Because there's different allegations for all of them.
Right. And I haven't reviewed who the 28 people are. I know a couple of them.
Got it.
So I don't know what their particular circumstances are, what the charges are, where they're charged.
Understood. Now, let me ask you this, Nathan. I mean, was it always something that you had in mind to say, I want to be a trial lawyer? Walk me through a little bit of your upbringing, by the way. So where were you born?
I was born in Iowa.
Iowa.
And I grew up in the Midwest. I went to college in Georgia. And then I went to Baylor for law school. And I graduated from law. I never knew a lawyer until I went to law school.
Never? No one in your family?
Nobody. And went to law school.
All right, Nathan. So, you've certainly given us some crucial golden nuggets here that I myself personally am going to walk away here and be a better lawyer. But, everyone has their own specific definition as to what success is
Sure.
and how it's defined in their personal lives. What would you say is success for you?
I mean, professionally?
Let's do both, professionally and personally.
Personally, as long as my kids feel like I was there for them as a father and they are able to be well-adjusted human beings going out into this world. On my personal life side, that's the biggest concern that I have.
Understood.
Taking care of my kids, I have 3 daughters, and I want them to be
Congratulations.
well-adjusted and successful, and I want to give them whatever I can give them so that they can really live life to the fullest, including, a worldview that incorporates seeing other cultures and other places and understanding how other people live. So I think that's important for them. Professionally, I always joke with my law partners right now. They're great at case generation. They're just Clive, one of my law partners, spectacular. They're the best marketing person I've ever met in my life. Like, he's just brilliant, genius at case generation, and a brilliant trial lawyer as well. For me personally, financial success is great, but I like the trial. I like to be in trial. I like to win. Um,
Just win.
and I like to be in the heat of the trial. There's a movie from 20 years ago or so called Heat.
I've seen it.
It's Al Pacino and Robert De Niro, and Tom Sizemore's in that movie. And there's a point in the movie where Robert De Niro is telling Tom Sizemore, hey, you should get out. You already have enough money. You've got everything you need. Just go, just ride off into the sunset. And Tom Sizemore says, yeah, but, says, Neil, for me, the action is the action. It's not the money.
Or the fans still going to love me. I'm not in it.
It's the action. Am I going to feel alive if I'm not in the battle? Right? So for me, I just like that. Right?
Understood.
It's just where I am. I like to be in trial. I like to try cases. I tried 3 civil cases last year. I like to be in trial. I like the battle. I like the intensity that it brings to my life. I like the stress that it brings to my life.
Embrace it.
Yeah. It makes you feel more alive. And when you're in that moment of not knowing what's going to happen and you put everything you can into it, it makes you feel, for me, more alive. And so for me, the financial success is one thing. That's great. Recognition from peers is one thing. But winning
Is where it's at.
is a thing.
Got it.
It's a thing.
These are really good goals, of course. Now, do you see yourself practicing as a trial lawyer all the way up until your old age?
Yes.
You do.
Yeah.
Until the wheels fall off, huh? Understood.
I've always said, why would I ever give this up? Right? I see the things in federal court. I see the things that are on the news. I see the things that people write books about. People watch TV shows. There are movies about it. Right? I see that. I see those things day to day. Why would I ever take my hand out of that game if I can still do it? Right?
Love it.
I represented the number 2 heroin trafficker in Africa a few years ago. And, that's, if I wasn't still practicing, I wouldn't have that, right? He got extraordinarily renditioned from the Seychelles Islands. They had done a sting and he had sold some heroin to an undercover FBI agent. And he went to meet the agent and they put a bag over his head and put him on a G6 and flew him back into the United States to prosecute here in Houston. He'd never been here.
At all.
Ever.
Never once touched Houston.
Never. Right?
My God.
If I stop, I won't have those stories.
I agree. I
So-
agree.
At some point, you have to say, it's worth it to keep going.
Love it. Love
Worth
it.
it to keep going.
Now, in your perspective here, for other younger lawyers, for those individuals that aspire to be lawyers, great trial lawyers who want to have that veracity and that energy to say, I want to win, what are you, off the top 3 things that you think people need to have to unlock success in becoming a great trial lawyer?
I mean, you have to have clarity that really is what you want to do, right? Because there's a difference between saying, I want to make money as a lawyer and saying, I want to be a great trial lawyer. I knew some spectacular trial lawyers who were at the DA's office. I know some great trial lawyers at the U.S. Attorney's office. And they're never going to make a lot of money, but they're amazing trial lawyers because they respect the craft and they want to hone it and they want to do that because that's what they feel passionate about, right? So if you have that clarity, this is what I want to do, that's step 1, right?
Okay.
Step 2 is the discipline.
Gotta have it.
Yeah. Watch the body cams, read the reports,
Dissect everything.
go through the Title III wire intercepts and highlight everything, right? I mean, that just becomes, and then you have to know the law. That's all part of that, right? And then, number 3 is you have to be determined. Don't stop.
Stay
If
after.
you really want it. You really want it. You have the clarity of what you want. You have the preparation.
Go get it.
You got to take it.
Love it.
You got to push for it. Right? Mario, you know this.
Absolutely. Absolutely. This has been a grand pleasure.
Thank you. I appreciate you letting me come on.
Of course. It's certainly something that, has enlightened me, as I mentioned to you, and I think it'll certainly enlighten quite a bit of folks here. Quickly, before we wrap it up, do you have an idea as to what exactly you want your legacy to be? When people say the name Nathan Mays, you're no longer present, what do you want your legacy to be like?
Well, I don't expect a whole lot of that.
Okay.
It probably won't be like that, but I would hope that there will be a few lawyers that I have mentored along the way who would say, I learned from somebody who really taught me the principles of becoming a great trial lawyer. Because I certainly did, right? I've had the opportunity in my career. I worked with Chris Flood, who's an amazing trial lawyer. I officed with Dan Cogdell, who's an amazing trial lawyer.
Yep.
I've officed and been partners with Ken Schaefer, who's an amazing trial lawyer. I've had these opportunities in my career to learn from people who really kind of embody what we think of as a criminal defense lawyer. And so I hope there's a few people that I leave behind who say, oh, well, I did really learn something from this lawyer.
Beautiful. Thank you so much once again, Nathan.
Absolutely. My pleasure, Mario.
Hopefully everyone enjoyed. Stay tuned for the next one, guys. Bye-bye. Fantastic.